Good morning, Professor.
Good morning, everyone. So, this is going to be a chapter on privacy. So, let's talk about why is privacy important and what it means to us as individuals, and how is privacy important in terms of cyber law policy and ethics, and how is privacy is also important in terms of an organization and what kind of legal ramifications you might have. What are the legal remedies you might have as individuals or as organizations? And I'm sure you all understand and respect that privacy is very important for all of us as individuals. We want our privacy to be protected and it should not be violated in any circumstance. So let's get in and find out what privacy is all about and what are the legal and ethical ramifications. Now, privacy itself is a constitutional right. So in the US Constitution protects the right to privacy and to your own personal space, your belongings, your home, your property, your assets. And obviously, everybody has that kind of constitutional right. Say, what happens with, say, one of the examples is an auto rental agency that's tracking the speed and direction of a customer. You go and rent a car, and then you're actually traveling. So the auto rental company that has rented you the car is able to track your speed, knows when you're stopping, also knows which direction you're going. Uh, don't you feel like, this is a violation of your personal space? What business does this auto rental company have in figuring out where you're going? How long have you traveled? How quickly are you going? You're giving up your personal rights in that sense. The FBI has advanced technology to track through thermal global imaging if there is a cultivation of marijuana, and that's an again, do they have a right to do so? So these are all examples where we get to think that privacy is being given away, and your constitutional right is being taken away by certain organizations, by certain companies and businesses. Surveillance cameras in public spaces. You're also aware that there are a lot of surveillance cameras everywhere, both for traffic control, for security purposes, for making sure there is less crime. But is it also not taking away your own personal space? That's something that you want to question and ask yourself. How much of your personal space and privacy is being compromised in terms of what other agencies or businesses are doing? I'm sure you're also aware that your own companies, your own employers are actually monitoring your computer usage. So suppose you're at work and you're doing some online shopping, your employer can see how long have you been on, a shopping portal or shopping website, and also they have an access to your email. So I've often been told whenever I want to apply for jobs, when I'm currently employed elsewhere, they say, "Hey, Prabhakar, don't put your applications on through your official email. Write something off the grid. Use your personal email because your employer is able to monitor your emails, what you're sending, if you're applying for jobs or not." And also they monitor how much time you're spending on Facebook, on Twitter, or on social media web pages, or even for online shopping. Now, that's an infringement of your personal space. Though you might argue, employers might argue, we pay you for 8 hours of work and not for shopping or engaging in social media. It's still an infringement on your personal space in that sense. So, for you and me to be aware that these things happen in real life, it's just getting us more prepared and being more aware what might happen. And you want to be careful when you do certain things. Websites collect information using AI and machine learning. You know that the companies are collecting, your searches. And the moment you start, suppose me, I search for cameras and lenses and camera accessories. And so Amazon throws up all the kinds of cameras and lenses and deals and price discounts. And if the price has gone down, it pops up on my, web page. And as soon as I click on the Amazon app or Amazon web page, it knows exactly precisely my buying pattern. What are the stuff that make me interested? Now, are they supposed to collect all your information? Maybe you will say it helps me because they know exactly what I want. It makes my shopping experience that much more easy. But on the other hand, they're collecting off all the kind of personal preferences you have without your written consent. So there is an infringement of your privacy in terms of collecting data without your knowledge, without having your explicit approval. So privacy is a matter of concern for everybody, and we are talking of what might happen in the cyberspace, the kind of crime that can be committed when your personal data or information is being accessed by, say, any of these agencies or companies or individuals or rental organizations. If they're collecting your information, they could misuse it, they could sell it. And they're not doing just for you as an individual, they're collecting it for a lot of individuals. So they have a big source, a big database of valuable personal information, including identification, your credit card details, other sensitive and confidential information can be with them. And this is something that you don't want to be misused against you. So as I said, it's a constitutional right in the US that you have your rights to your own privacy. The Fourth and Fifth Amendment speak to this, the right of people to be secure in their own homes as an individual, any papers, documentation against unreasonable searches. Nobody can come into your home and start searching your premises or your property or the papers or documents that you possess without having a proper search warrant that has been issued, and it has to be issued supported by an oath or an affirmation. And only then they know exactly the designated places that they can search and they are authorized to search. Otherwise, the Fourth Amendment of the US Constitution protects your own rights towards, privacy as a person, privacy as a property and your home, and any of the documentation and papers that you might possess. They cannot come in and start searching and infringe on your privacy without having a proper search warrant supported by an oath or an affirmation. The Fifth Amendment also protects, individuals like you and me against government actions. No government can actually force you to self-incriminate and hold you to be an evidence against yourself. So no person shall be compelled in any criminal case to be a witness against oneself. So the Fifth Amendment, gives you that kind of protection in terms of protecting your privacy and making sure you're not being under pressure by a government, source or an agency to be a witness against yourself in any criminal, legal pursuit. So this is about how important privacy is in terms of, say, the U.S. Constitution having these as your rights. And I'm sure every other country across the world have privacy as a major cause of concern. They have their own legal systems and their own constitution, whether it's federal law or state laws. They all try to protect your privacy and make sure that your rights are not infringed on. This does not apply if when a person has some information that they want to self-disclose. Suppose I have documentary evidence which I want to turn in, records and files and papers to a law enforcement agency. In such a case, it's not infringing on my privacy because I'm doing it out of my own volition. I do it of my own free consent and will, and I'm doing it voluntarily. So if I turn in those papers and give a law enforcement agency access to documents or files, that's fine. It's not an infringement in this case because I'm doing it out of my own, voluntary action. The Fifth Amendment, as we spoke, also, has an implication for cyber law application that you and me have a right to encrypt a file. Suppose I'm signing off on a document and I don't want, it's an electronic signature that I've used for signing a document. I don't want someone else to be misusing my signature. So I could encrypt a file, but if in case that encrypted document has stuff which is potentially criminal, in such a case, an employer can secure permission to decrypt the particular document, have access to the encrypted document. And if they find that I've had some potentially criminal information encrypted into a document, then employers can have the right to fire an employee and provide the document to the law enforcement officer as an evidence of why they found this document to have an potentially criminal information encrypted into the document itself. So obviously, with a proper, law enforcement authority, they can do a valid search warrant could be issued, and then of course you can have access to the encrypted file. they can do an investigation so that they can make sure that you're not misusing the option of encryption against the business or against the society at large. So the Fifth Amendment of the U.S. Constitution speaks to the cyber law space as well. In addition to the U.S. Constitution, several state constitutions have a source of privacy rights. These rights, mirror exactly what's there in Amendment 4 and Amendment 5 of the U.S. Constitution. So privileged communications, what a client tells, for example, to an attorney, when I'm disclosing certain stuff to an attorney, these information which I'm disclosing are confidential and they're not supposed to be shared with anyone else. So is the case with when a patient tells a physician, this information that I'm disclosing to my physician or a medical practitioner should not be available to anyone, including government officials, unless I choose to disclose them or the patient discloses whatever information they want to disclose. So attorneys, doctors, psychiatrists communicating confidential information to their clients or patients should seek the most effective methods such as encryption to protect them, safeguard this personal information so that others do not have access to it. So that's another thing that you want to keep in mind, that there are a lot of information that we want where we protect our own privacy and make sure the confidentiality is not compromised. Now you have the law of tort, where law protects causing of harm by one individual to another, and that's what we call the law of tort, where the legal remedies are available to prevent one individual hurting another individual. So there are different cases in terms of law of tort which pertain to privacy. The first one is intrusion upon seclusion. Now, each one of us have a right to be let alone. I have a right to stay and confine myself in a particular space. I have a right to be let alone, to go to a place of seclusion. Suppose I say, hey, I want to sit in my bedroom. I want to sit here. I don't want anybody to disturb me. I have a right to do so. And that's also, supported by judgments that have happened in the past, precedents that have been set apart. And the law of torts actually reiterates the fact that, I have a right to be secluded, to be let alone, and any intrusion is a violation of my privacy. So this, like most of our legal rights, is not absolute, meaning which, suppose when another individual without permission or legal justification violates that place of seclusion, this tort could provide a remedy. That's the normal understanding. Suppose I'm here, I don't want anybody to disturb me in my home, in my space. And if suppose somebody comes in without permission or legal justification and violates this place of seclusion, which I have a right to, then this tort could provide a remedy. I could fight it out legally and complain against the person who is actually violating that place of seclusion. But in order to succeed, a plaintiff needs to prove, as a person, that I feel my place of seclusion has been violated. I need to prove there was an intent to intrude or knowledge that the intrusion was wrong. If I can prove that you came into my space and you're infringing on my privacy or the place of seclusion, and I have to prove that you had the knowledge that the intrusion was actually wrong. It's on me. If I'm filing a case and I'm complaining against you, I'm the plaintiff. So as a plaintiff, I have to prove that you came into this place, intruded into my place, and you had the knowledge that the intrusion was wrong. There was a reasonable expectation of privacy. I mean, this is my home. You can easily sense that this looks like a home. It doesn't look like a public place. And I can prove that this doesn't look like a government office or a public place. And it looks like a home. It has a periphery. And obviously, there is a reasonable expectation that this is private property. And you can not infringe and be intruding into that private space. So intrusion was substantial and highly offensive to a reasonable person. I mean, I've seen a lot of times a car come and back up into my driveway and take a turn. We understand they're not supposed to come into private property, but also it's very obvious they're not coming in to stay here, or they're not coming in to, disturb me or use my personal space. They've just backed out into my driveway because they've forgotten how to go to the place they want to go, or maybe the GPS was not leading them to the right place, and they backed up a little, waited for the traffic, and then moved out. For me, that intrusion is not substantial and it's not offensive. So obviously, I cannot be the plaintiff and complain that my, private premises or home was intruded into. There's no intrusion upon seclusion, though it is my private property, my driveway is my driveway. I cannot prove to anybody in the legal system. And as a plaintiff, I'll not be able to prove that this intrusion upon seclusion was substantial, it was highly offensive. So in this case, as a plaintiff, I cannot make the complaint. I cannot win this argument. I'll not have a remedy under the law of tort for infringing on my privacy in this case. Any questions? Now, exceptions are there for everything that you talk in terms of privacy. So suppose if you possess some pornography, I mean, and the word gets out there that you're doing something illegal in your home, every time a law enforcement authority can come in, they don't need to say, hey, this is private space, you could do whatever. If you're breaking the law, then it's possible that they can come in and have a search warrant with them under an oath or an affirmation. They can search your property, they can search your personal documents, your belongings, and if they find incriminating evidence, legal action will follow. So there are, exceptions. If you're doing something criminal, and if the word gets out there with a proper search warrant, they could come in. It's not an intrusion of privacy anymore. It's law enforcement. You're taking care of the community and society at large, and your law enforcement or legal enforcement authorities have the right search warrant. They can come in and search in your private property as well. Now, this is an interesting case, which is there right below here. Now, CADS is making a phone call in a public space, a public phone booth. And even if it's a public phone booth, it's not just he's thinking, hey, I need that space to be enclosed. I don't want somebody to see me. But also the important case that somebody should not listen to me, because it's a public phone booth. It doesn't mean anybody can listen to me. He's having this understanding and trust that this is a space which is in public location, but then it's again, privacy has to be protected because it's a personal conversation. I'm just using infrastructure which is there in the public space. I need privacy. I don't want somebody to listen to me. Now, the petitioner sought to exclude when he entered the booth was not an intruding eye. It's just not somebody seeing me, but I don't want somebody to listen to me, even if I'm using the public telephone booth. So if somebody were, say, tapping into such a conversation, or if they were listening into such a conversation, even if I was using a telephone booth in the public space, it's an intrusion into my privacy. So in this case, the court ruled in favor of the person, said nobody should be able to tap a public telephone booth or listen to a conversation. And because it's an infringement of your personal space, it's an intrusion to seclusion. And obviously, in this case, CADS actually won the argument and the court ruled in his favor. So that's an interesting case. At the end of today's class, what I'm planning to do is I'll make sure I'll have, a case study for you, which you can have it in breakout rooms. You come back, it'll be only on privacy. And it's a short case, like last class. I'll give you like 30 minutes time for you to go back and read the case, understand the case. I'll have 5 questions, 5 teams. Each team will answer 1 question when you come back after 30 minutes of discussion in the breakout rooms with your team members. Now, privacy in the use of cell phones, you know that we're all being advised, hey, they're watching you, they're listening to you. This is a real case where one plaintiff, the chief negotiator for a teachers union, made a cell phone call to another plaintiff. So there are 2 plaintiffs here. One plaintiff is the one who complains, who feels that some wrong was done. So in this case, one plaintiff, who's the chief negotiator for a teachers union, is making a phone call to another plaintiff, the union president. So the chief negotiator is talking to the union president, in which they discussed ongoing contentious union negotiations. So they're talking of something that's pretty much confidential. They're talking something that is contentious. And who's doing that? The chief negotiator and also the union president, both of whom are making a complaint. Now, they're making a complaint against, you see the second bullet point, it talks about the defendant. In this case, they're making a complaint against an unknown person who is legally intercepting the call and recorded the call and send this call recordings to other defendants who are defending themselves and played it on the radio, who are other defendants who got the recording, just played it on the radio, made it public of what the chief negotiator was talking with the union president. Now, the plaintiffs, in this case, the chief negotiator and the union president, were upset that their phone call was recorded by one defendant, shared with other defendants, and the other defendants played it on the radio. So the two plaintiffs, the people who are complaining here as the chief negotiator and the union president, they're upset, they're angry, and they feel that their privacy rights have been compromised, and they filed a complaint. Now the defendants are defending themselves, and they argue that the conversation contained information which the public should know. It's of importance to the public, basically, and they are supposed to know, they have a right to know what's going on, what's cooking. So the court in this case agreed that privacy concerns of the plaintiffs were outweighed by the freedom of speech and press rights of the defendants to communicate information, even though it was wrongfully intercepted, even though recordings were not done properly. It's an infringement, but the pros and cons, when you look at it, the public should know the truth. They have a freedom of speech, they have press rights, and the public are supposed to be made of the truth, aware of the truth, and there is a significant interest to the public that they should be aware of that particular information. And in this case, the plaintiffs lost the case because the defendants, though wrongful methods were used, they are using what we call as freedom of speech and press rights to record a phone conversation. And this is of importance to the public, and they have a right to know the truth. And so the defendants were actually protected. There could be nothing done against the defendants, basically. So this is another case. I'm giving you a case example so that you understand privacy and what it means in terms of legal terms, different scenarios, and how they get interpreted in the space of cyber law, and what is the ramifications that you have. Now, the second type of things that can happen in privacy space in terms of cyber law and ethical issues is public disclosure of private facts causing injury to your own reputation. Now, it's funny that this type of tort, again, the law of tort is, trying to prevent one individual harming the other one, and the law of tort actually provides you a remedy in trying to make sure when there is a harm done by one individual to another, what's the recovery you have. So this tort that addresses public disclosure of private facts causing injury to somebody's reputation allows for recovery when highly personal facts or information about another person are publicly disclosed or transmitted, whereby it damages the reputational capital. It's like a defamation. So the facts must be private. You're not supposed to know. Even if I'm a celebrity, even if I'm a public figure, there are certain facts that must remain private. And if somebody else actually discloses those private facts, hurting my reputation, hurting my image, so obviously I have, a remedy. I can be the plaintiff. I can complain, and I can sue the person who has done something like this to me. The communication or publicity must be disclosed to a significant segment of the community. Suppose if that disclosure is done to one another person, that's not significant segment. But if the word gets out there and the publicity actually addresses a large gathering, a huge population or a big size of an audience that can again spread the word, in that case, there is definitely a case of public disclosure of private facts that are injurious to a person's reputation or image. So this is another infringement of privacy rights. Now, publicly placing another in false light, suppose you were having allegations which are false, and you actually connect a person to something that's immoral, illegal, embarrass them in terms of what you're stating, which result in damaging a person's reputation. Again, you might call this as a case of infringement of privacy rights. Even on email, by the way, because you're all tech students, you're all in the computer space, and you're all in data science and cybersecurity. You also should be aware when you write emails, if you're writing caustic emails, malicious emails, you're defaming somebody in terms of your emails, you're using inappropriate language to describe somebody, you have a right to what we call as Freedom of Information Act. So the act, you can actually pull all the emails that you suspect might have been written across in the organization, which are presenting an individual in poor light or hurting the image of the individual or causing a damage to one's reputation. All such emails can be pulled. And if you have one evidence, one email is enough. If you have one email that clearly proves that either whatever you're writing is damaging a person's reputation, or as a personal malicious attack on an individual, or you're preventing someone from doing their job properly, that could be legally pursued, and you will have a remedy under this kind of law of tort, where you're having a case of publicly placing another person in false light, using bad language, misstating facts, and hurting a person's reputation and image. The fourth case of tort, law of tort, is misappropriation of a person's name or likeness, causing injury to a person's reputation. This tort applies in cases where a name or a picture of an individual is used for commercial purposes without the person's permission or consent, even a caricature of an individual, but it's very obvious this caricature belongs to a person. And if you're using it for commercial reasons without a proper permission or approval or consent, then in such a case, there is an infringement in privacy rights. And this is exactly the case of this particular law of tort, which is misappropriation of a person's name or likeness, causing injury to a person's image or reputation. And in states like New York, it can result in both criminal and civil charge. Law of tort, I forgot to tell you, is a civil law. But in New York State, something like this can lead to a criminal charge as well as a civil liability. Now, as an example of this particular thing, we have an example of Weld versus CVS Pharmacy, disclosure of private information about patients, their illness or medication. So I have a little bit more detail on this particular case study. The case Weld versus CVS Pharmacy deals with disclosure of private patient information by CVS Pharmacy because they have a lot of access. They have database of what medicines you're taking, your ID, your insurance, and all the other stuff. The CVS was accused of disclosing private information regarding patients, their illnesses, medications to third parties for marketing purposes without the patient's consent. So the lawsuit that was focused on the violation of privacy rights and the breach of confidentiality that is supposed to protect patients' medical records. We just talked about it a while ago. This is very confidential information. Any of your medical records cannot be shared with a third party for whatever purposes of doing business or marketing. You're not supposed to be doing that. So in this case, Weld versus CVS Pharmacy, this is a clear case where CVS Pharmacy shared the information, which is pretty much confidential, to third parties for marketing purposes. So this case is significant because it highlights the legal boundaries surrounding the use of sensitive health information. It raised concerns about how pharmacies and healthcare providers handle private data, especially in the context of HIPAA, Health Insurance Portability and Accountability Act regulations, which clearly state that individuals' information pertaining to medical information are extremely confidential. And the case also emphasizes the responsibility of healthcare institutions like CVS Pharmacy to safeguard patient information, avoid exploiting it for any commercial purposes, marketing or sales or repeat purchasing. You're not supposed to share it with a third party because this is extremely confidential. And it's also having the protection under the Health Insurance Portability and Accountability Act. So that's about all the types of law of torts that pertain to the privacy rights and infringement, and what kinds of civil legal ramifications you have, apart from the ethical side of it, where you are supposed to be responsible as an employer, as an institution, as an agency, not to infringe on anybody's privacy rights, which is protected by the US Constitution, Amendment 4 and Amendment 5. Any questions? I'll be happy to take them.
No, Professor.
Okay, sounds good. So what I'll do basically right now is, you know, have you in breakout rooms. I'll create 5 breakout rooms. Before I put you in breakout rooms, I will share the file so that you have the case study with you. And once you have the case study with you, I can put you in breakout rooms. The important thing is read the case as a team, talk to each other, because that's the idea of these discussions, that teams have great ideas. Innovation is more when we work in teams, when we collaborate in teams. So I want you to talk to each other, also know each other, make friends with each other, and also have a chance to look at the case study together, analyze the case. Team one will answer question number one. Team two will answer question number two. Team three will take question number three. Team four will take question number four. And team five will take question number five. There are 5 questions at the end of the case study. So this way you don't have to answer all the questions, and you can only answer the question number which has your number on it. So just please confirm if you got the case study in your chat. You can download it on your computer. It's a very short case. And as I go and make you in teams right away, I can actually put you in 5 teams. I'm just doing that randomly. And you will get a prompt to join your breakout room. It's about 10:05. We can come back at about 10:35. And then you can all present, and that'll be the end of the class after I listen to your presentation for each question. I would highly encourage you to stay till all the teams present, because there are 5 different questions. I want you to stay, and then I take your attendance after the end of the 5th team presenting. Okay, you can now join your teams. Please download the attachment. Hayden, you can join team one.
I'm sorry, I was clicking buttons. It wasn't working now, Will.